So, in the past lecture, we had seen regarding the moral reason for managing health and safety. We had seen also the financial reason, like financial impact that happens if health and safety is not followed. And today, we are going to see the legal reason for managing health and safety. Some points we had taken in the last lecture. So, today we shall elaborate it little. So, why legal requirements matter in health and safety? We had discussed this. The both things can be compromised. The first two things, that was moral and financial. But legal duties cannot be ignored and it cannot be compromised because law is mandatory. A company begins, it operates, it regulates, it runs, it closes. In all this process, the law is there. Like how when a child comes to birth and in his entire lifetime and he becomes an old person and if he faces death, in the complete process there is legal thing that happens from his birth, the birth certificate that is legal, until the death, the death certificate, the legal things follows, and that cannot be avoided. It's always there. So same like that for the companies also, in their each and every process the law is mandatory. They should have to follow the compliance, which are the safety requirements. So the law will say that there should be safety policy, there should be health and safety law to be followed, there should be requirements of safety materials to be provided, there should be proper safety rules to be followed, there should be good standard of safety practice to be followed, there should be good governance to be made, proper regulations should be followed, there should be transparency in the health and safety practices in that particular industries, factories, everywhere. So the law is very strong. And in the three pillars of why health and safety to be practiced, or like what it matters to practice health and safety, this third pillar is very strong. And with the strength of this, the other two also gets its strength. And when these three things are combined, that becomes the strongest reason to follow health and safety. If this legal thing is not followed, which means the requirements or the compliance is not done, it will lead to penalties, it will lead to prosecution, and it will even lead to closure of the industries. We know what has happened to Bhopal, like the Union Carbide company, after that incident, after that accident. Today also it is closed, that plant. Hence, why it is important to understand legal duties are enforceable. The enforcement agencies or the enforcement authorities, they can inspect, prosecute, and penalize. They have the duties, they have the responsibilities, they have the power that has been given from the law. And also, if in an industry the health and safety practice is not followed properly, which is leading to an accident, that could be major, that could be like any of the condition, the managers are liable for that condition. Now understand this properly what I said. If the health and safety practice is not being followed properly, that could be like proper budget was not given for safety, required material was not being provided in the safety department, and like safety work or the safety like required trainings and all these things, they had didn't given any importance. They didn't give importance for like audits and all these things, which means they didn't had a good health and safety practice been followed, and they were only completely targeting and focusing on the production. And due to that, a major health and safety lapse or poor conditions happened, which had lead to an accident. Now, in such conditions, okay, so in such conditions, the managers are liable for that accident. Now, why? One of the student has asked me this doubt that not only one, today even the experienced safety officer has also this doubt that if an accident happens, the safety person is responsible for that. He is personally liable and all these things. Now a question arises. Just think if it is a construction industry, if it could be a shipyard, it could be like a factory, it could be a chemical factory, all these places. And here there are different managers. Just think if it is construction industry, project manager is there. If it is an industry, there is a there is a manager allotted for that. If it is like a if it is like a shipyard, there are managers for that, project managers. And if it could be a factory, then the factory manager is there. So such type of managers are there. Just think now here in all the places I said, there are safety people also. Now the safety person could be like a safety officer, safety engineer, senior safety officer, or it could be assistant safety manager, any of the posts. Now the question is, who is planning the work? Who is allotting the budget, making the budget? Who is providing the resources, allotting the resources? Who is providing and allotting the resources? Who is commanding the work or like enforcing the work? Who is doing the production? Which means very simple thing, like who is saying to work in production. So the production team actually they are planning the work, they are making the budget, they are enforcing the workers to work in such conditions, and all like they are doing the plannings. So they are working. Work is being done by them. So when they are doing the work, they are planning the work, they are like targeting, doing the budget and all these things. So when that particular work is completed, who gets the result? They itself get the result. This particular team itself get the result of that thing. Which means just think if they have done a good production and they have achieved it in a good like say target, so they get the results and they get the benefits or which means they are being appreciated for that work. So same like that, when this work while doing an accident happens, then it is a failure of that particular production department itself. Because just a simple example, just think you are a student and at your house you wanted to go in a height to work. So you use a ladder and that ladder is not in a good condition, like it is not proper, which means it is a wooden ladder and all the wood planks are like completely uh, not in a good condition. It will not be able to like withstand your high weight. There are chances it could break, but still you use it for working and you climbed and that break and you fall, you have been injured. Now for this thing you yourself are responsible for that, because you are doing a certain work, you know that work, You know by doing that work what risk will come to me, and you have ignored that, and you have done it, and you finally have got injured. That is the result that came to you, the output. Same like that, when the manager is planning, designing, budgeting, allotting the labors, workers, and everything, so they know properly that like what risk will come to us, what dangers will come to us, and hence by what are the results of that outputs and everything. And hence by we should have to understand that we should have to understand that people who are commencing the work, and that too which leads accidents, dangers by their like not complying or not following the proper health and safety requirements, they are actually liable for that thing. In such conditions, the managers are liable for that. In such conditions and situations, you should have to understand this thing, very much important thing. In such conditions, the said managers and their department are like liable for it, the accident. One basic example I will say to you. Just think, if it is a construction industry, there is a project manager, below him there is a senior engineer, below them there is a junior engineer. So there is a building. So in that building, what happens is the engineer says that I need this work. The senior engineer says that I need the outer work to be completed within 1 hour. He gives a target to the worker. Now outer, which means, just think, the building is there, outer section, okay, outside. So there is a danger, if he loses the balance, he could fall down. So he says that there is no like anything to protect the downside. So it is in the second or third floor, just thing like that. So he gives a target, and now the senior engineer is giving the target. Below him there is his assistant, that is a junior engineer. Above him there is the project manager who has commanded him. He has said that I need the work to be done within this much amount of time. You are not like a competent person and all these things. So both are there in pressure. And again, what happens is the senior engineer commands to the junior engineer, like, you should have to stand over here, look the work, and make sure that work is completed. So all are there in the pressure. They want to achieve a target. Now here, the worker should have to go outside and do the work. For that, as we said in the beginning, we had shown there is a PP, that is called as the safety harness or safety belt. Okay, a belt is there and it has a two clamps. So that clamp, while working, you can hook it, and even if you fall by balance, slipping, or any of the thing, this clamp will protect you. You will hang in that. Basically, just think of that. Now, what has happened is the work needed to be completed in 1 hour in any of the way. To and the work will, when if he does the work, it could be like a painting, it could be like any of the work, hammering or whatever work that requires 1 hour. So if he is required to go in the office and issue the material, like the uh, safety belt, and take it from the store and again come to the site and work it, it will take like around, just think, 30 to 35 minutes. And he has a pressure from the engineer, so he understand he cannot do that. The junior engineer also says that you do your work, uh, compromise on the safety belt and safety, just do it, and it's only just 1 hour work, complete. So he listens, the worker listens to that particular junior engineer and goes, and where he has was standing, it got collapsed, and he fall from like the second floor or like third floor, just think. He had got a major injury. His head has a major injury. He got fractures, multiple fractures, and all these things. Now, in such a condition, when The production department, they had not followed the required compliance to follow basic health and safety practices. In such conditions, who is liable over here? It is not the safety officer over here. Now, again, here, why I will say to you that also. As I said, you production work, the work enforcing is done by the production team. The safety officer, safety department, these people are actually known as the advisory role. Example, the doctor advises to the patient, the lawyer advises to his client. The safety people, they are also as an advisory role. They are not in production, they are like a professional advisors. They advises the work, like what work they are doing, what work the production is doing, they advises it. It is to be done like this. There are issues in that. He inspects, he advises. So understand the role over here. When you understand the role, you get the responsibilities what needs to be done. Manager's role is production, and hence by his responsibility comes to follow health and safety. If not followed, then he himself is going to face a condition. Now the safety officer, he is an advising position. In the production, if there is any fault, he advises, like, you should have to wear this particular safety belt or harness. If you're working in this ladder, he will inspect it. If it is not good, he will say you should have to change it. To whom? To that particular site's manager in charge of that place, or the upper management, senior management, that I require this amount of thing, these materials. If the worker, like the safety officer has said to the worker, you wear the harness and all these things, and the safety officer leaves at particular site. This engineer has commanded him to work without this particular thing, and leading to such accidents, the production team is only responsible. That particular people, the engineers, because see they have done this some sort of like unethical practices that is not accepted. In such conditions, never shall the safety officer be held liable for that. He is in an advisory position, and never and not is not responsible for that. Now, the main thing that comes is that is the law. Even the international law also accepts this. Also, in the UK law also, it is clearly said that the managers or the directors, they are responsible, because they are actually who, see, for safety to run properly, work smoothly and everything, they require the budget and all materials and all like required assistance from the senior authorities. And the upper management also understands properly that what is going below in the safety department, how it is working, which level of excellence are they doing the work. But from the senior management, if they themselves is not providing the required things, it cannot work smoothly. And hence by we need to understand this thing. In the UK law also it is properly said. In the Indian law also it is properly said. In everywhere, as per international, in every country this is same, that a person who is the manager of the site, he does the work, and hence by when he does the work, he himself should have to make uh, like he himself should have to make sure that health and safety is being properly followed. Simultaneously, you do a work, you make sure that health and safety has been followed, which means here as a condition, if the engineer wants that particular person to work on the buildings outside and the work to be completed, the engineer should have to same take the particular safety belt, make sure the health and safety has been followed properly, and you do the work that needs to be completed. So this is the like working condition that needs to be followed. So this is an important point that everyone needs to be make sure. And by understanding this thing, we now understand that the managers are at like risk, or like they are liable. So we should have to make understand the managers, such managers that could be project manager and all these managers which we said, that they should have to, they should have to, like the safety people should have to make sure, the health and safety practitioner, they should have to make understand the managers that there is such type of risk. If they themselves fails to follow it, then they are being going to be liable for that. Even the top senior management, they also faces these issues of like inspecting, prosecuting, and penalizing, and all these things. And see, majority of the people, they are unaware of this thing. They are unaware of this thing, and hence by this level of knowledge, basic knowledge should be there. So what happens? People start to follow the basic health and safety practice. Slowly, slowly, they improves it. In most of the places, as I said you in the last lectures also, accident happens, blood falls in the ground, which means like it could be minor, major, catastrophic accident. Like people's blood falls in the place, and with that accident, what happens? There is some change, and the good health and safety practice slowly, slowly starts to improve in the site. So mostly this thing should never happen, that worker or any other people have to follow such conditions. So this basic like training, knowledge, everyone should have, and hence they should have to follow the health and safety practice. So now going to next. So now we are going to see, as we discussed regarding the international laws and everything before also. Now let's go a little deep into that. So here we are seeing the international legal framework for health and safety. See, there is the United Nations. So they have this agency, that is the International Labour Organization, ILO agency. So the international legal framework for health and safety is been provided by the ILO. So there is a United Nations, and under them they have their agency of ILO, and this international labor organizations, they provide like the health and safety and working conditions everywhere. They give the standards how it should be followed. They give the improvements how it is to be done throughout the entire countries, which means ILO sets the international health and safety standards. Now, why I will say to you, just a simple thing. During the time of World War, there was requirement of tremendous amount of ship in the navies of different forces. The Japanese Imperial Army, the Royal Navy, the US Navy, and all different countries, they were in war, and they were requiring too much amount of like indigenous strength, warrior ships, warships, and everything. The time that they require to make the like complete this particular ship, it could be ship, it could be aircraft, it could be like any of such things. Those were very less time, which means there were manpower who were working like there were no time like today we have like 8 hours, 12 hours pattern and all these things. There was nothing time, this time, that time, there was no such like time being mentioned. They were working day, night, continuous. They were working with days and all these things. And they were to be worked. There were no options for that, which had affected the people's health condition in the workplace. There were no legal support for health and safety concerns and the working conditions worldwide in most of the countries. And due to this, due to this, the ILO had improved the safety, health, and the working conditions code, the 8 hours pattern, no child labor, and all these things was brought by the ILO, International Labour Organization. So all these improvements came from here, and hence why all the countries accept these standards and they follow it. So what does the ILO give is they provide conventions and recommendations. Now, what is a convention? See, it is a legal binding treaty in which it says what how you should have to follow health and safety. And in recommendations, what happens is the same thing, how to follow health and safety. In recommendation, it becomes practically how you can implement it. Like it is like a guidance. Recommendation, which means it is like complete guidance, practically how you can perform it. When convention is complete, like the mentioned thing how to do, like what is like how you to follow health and safety, and recommendation is completely the guidance for that. So we will see this next. So this convention and recommendation is followed by the countries. Today in ILO, more than like 185 above countries are there as a member. And in that, most of the countries follow these conventions and recommendations. See, why we need to follow this international conventions and recommendations. See, convention and recommendation, understand this much only. It is a health and safety, it is a health and safety like framework for health and safety that needs to be followed. So, what happens is each and every countries they ratify it and they accept or like is being accepted in the national law of that particular country. So in that they will understand this the countries will make sure like how we can implement that in our country. But what happens is if in India the level of practice that how they will follow will be different as comparing to the US, will be different as comparing to the UK, will be different as comparing to the any of the countries in Africa, Russia, Japanese, and all these things. Because every country has their limitations and requirement. With that, they changes it. But there are some basic principles. Now, what is basic principles like? uh, there should be like basic health and safety practice to be followed. There are like basic safety things we will see later that. So basic principles should be followed, and that is to be done. Following international health and safety practices by the countries, what happens is we know that people in India work in like most of the countries. That could be European countries, that could be in Middle Eastern countries, in Russia, in anywhere. And from outside also, people will work in any places, which means people work internationally, and working in various sectors like oil and gas sectors, in such dangerous sectors, in such works, there are like people coming from different countries. So when you work in such conditions, if you are familiar with the international legal framework, you are familiar with the international health and safety practices, then the working conditions become same. Or else what will happen, if a person who is working in India, he knows that particular Indian laws, Indian health and safety practices to be followed, and if it is different as comparing to the UK, and if both the people, these two persons, and again there is a person that could be from like US, so he is following OSHA standards and everything. So just think if three people are following three different things and they are coming in one particular place to work, and he's unable, like he is not, these three people are finding difficult to work in that one company in one sector, that could be an oil and gas sector. Three of them are having different health and safety practices knowledge, so that will affect the work over there. So hence why it is very important that this international legal framework will create a minimum standard in health and safety across the countries, and due to that there will be a better safety practice that will be followed. And also what happens is this particular legal framework makes sure that every nation has a health and safety legislation, a health and safety law, and they have their foundation. What is the foundation of every country regarding health and safety? That is the legal system, that is the law over there. So when it is there, then gradually what happens, there are improvements in that, and this international legal framework helps in the health and safety progress in every countries. So now when we move forward, so all these countries, 195 countries, the countries adopt the international labor organization standards, ILO standards, conventions into their national law. They bring it. Okay, so ILO makes these conventions and recommendations like this thing, and the nations, the countries, they like make sure how can we implement this in our country, what all things can we bring in that, we can bring in that, and they then make these national laws, and that law is implemented in the countries. So every country's health and safety, like they have their health and safety like legislation, law. So everywhere it is different. Some countries follow little similar things, but see, the developed countries, they have a very good health and safety practices, so that will be different as comparing to the developing countries, because their development is going on. There will be little lapses, and hence by improvement happens over there. So practices, there will be difference, and similarly in legislation also there will be difference comparing to that. But as I said you, the third point over here, law may differ, but core principles remain the same, which means the basic principles to follow health and safety, as I said you, that could be like workers should be given PPEs, training should be taken, risk assessment should be done, There will be basic health and safety practices to be done. There are these basic things. Employers should have to make sure health and safety is followed. All these things, these basic things, basic principles, is being followed in every countries. Okay, so Indian law towards health and safety will be different as comparing to Russian health and safety law. So Russian health and safety law will be different as comparing to the UK. UK's health and safety law will be different as comparing to Canada. Will be different as comparing to France. Will be different as comparing to Australia. But the core principle remains same for everyone. Okay. Now we will see each and every country's main health and safety law and the supporting laws over here. So you can see over here UK, the main health and safety law is the Health and Safety at Work Act 1974. This is the main health and safety law that is there in the UK. And supporting that, there are like for different sectors, different industries, they have like different law. For construction, they have a law. Then you can see next that is for COSHH, for control of substance hazardous to health. They have the law. Offshore oil and gas safety regulation. They have a law. Regulatory reform for fire safety. They have an order 2005. Workplace health safety and welfare regulations 1992. They have a law. So here you can understand UK health and safety laws are based on ILO conventions and recommendations, which means UK is also following International Labour Organizations conventions and recommendations, as we said. Now this convention and recommendations we are going to see in deep, but first we will see like how many countries are following it, like what level of like are they following, and by following that the results are for the countries, the results are you see like the main health and safety law, which means UK are following this ILO conventions and recommendations, and hence by after that, like this, there are changes in this health and safety at work 1974. There are like good amendments being brought, and this main law coming to existence very strong by following the core principles and everything. So UK follows it. Now we have Germany. Their main health and safety law is called as the Occupational Safety and Health Act, Arbeitsschutzgesetz 1996. So here Arbeit, which means work, like occupational work. Schutz, which means safety, and Gesetz, which means law. Workplace safety law. You can understand like that. So in English, we can see over here Occupational Safety and Health Act. So this is their main law, and supporting different sectors, they have their sector specific laws over there. In the below, you can see here also German health and safety laws are based on ILO conventions and European Union directives. We know the European Union, they have the European countries have the European Union, and they also have their directives and everything for health and safety. So they follow that also. So that is also a good international practice. Different countries coming together, the European countries, and they are making a good standard practices. So we understand that they are giving a good importance in that. So Germany also follows the ILO. Now France, their main health and safety law is the French Labor Code, that is Code du Travail, which means law. Code means law. Du means code for travail, like work, labors for health and safety. So for supporting and sector specific laws, you can see over here. Different sectors, they have different laws. Now French health and safety laws are based on ILO conventions and same also again European Union directives. Here, as you said, seen the Germany, France also comes in the EU, European Union, and they follow the directives. Also, the ILO practice also, ILO conventions. Next, we can see is South Korea. Their main health and safety law is the Occupational Safety and Health Act 1981. You can see all the sector specific laws over here. And then South Korea's health and safety laws are aligned with ILO conventions and international standards. So they also follow the ILO conventions. See, you have the sector specific laws, but the main health and safety law is the Occupational Safety and Health Act 1981. Everything is mentioned in that. But what happens is, if it could be like any sector in which there are a lot of technicalities that comes. So to understand and go in that much guided like technical studies and make a proper health and safety practice laws in that, they have the sector specific laws in that, regulations, act, guidance, code, everything. So South Korea also follow. Russia, their main health and safety law is the labor code of the Russian Federation, that is 2001, and they also have their sector specific laws. Russian health and safety laws are aligned with ILO conventions and international standards. So, Russia also follows the ILO conventions and good international standard practices in health and safety. Now we have India. So, the main health and safety law of India is Occupational Safety, Health and Working Conditions Code 2020, OSH WCC 2020. So, this is the main law in India for health and safety. Now, you can see the sector specific laws for industrial, factory and construction. For factories, we have the Factories Act 1948. For the building works, the construction work, we have the BOCW Act 1996, Building and Other Construction Workers Act 1996. For the contract labor, we have the Contract Labor Regulation and Abolition Act 1970. For the interstate migrants, we have this Interstate Migrant Workmen Act 1979. India also follows the health and safety and follows the ILO conventions and recommendations. Now, we are also seeing some supporting sector specific laws. So, when there is high risk or technical safety, as I said you, that is required, they have like sector specific laws. They have Mines Act for mine sector, Mine Act 1952. In the boiler plants, they have the Indian Boilers Act 1923. For regulations of boiler, they have the Indian Boiler Regulation IBR 1950. To handle explosives and their concerning health and safety, they have the Explosives Act 1884. For petroleum, they have this Petroleum Act 1934. For the pressure vessels, they have the Static and Mobile Pressure Vessel SMPV rules 1981. Regarding gas cylinders and everything, LPG cylinders and everything, they have the Gas Cylinder Rules 2016. Regarding electricity, health and safety, they have this Electricity Act 2003. Now, regarding chemical and environmental safety, they have EPA or the Environment Protection Act 1986. Manufacture, storage and import of hazardous chemical MSI HC rules 1989 they have. For storage of hazardous chemicals, there are a lot of hazardous chemicals. We know what has happened in the Bhopal. They were having issues in the manufacturing, they were having issues in the storage and everything. So we have this law. Then we have the Chemical Accidents Emergency Planning, Preparedness and Response Rules 1996, Hazards and Other Waste Management and Transboundary Movement Rules 2016 for hazardous wastes. For water, from pollution control, we have this Prevention and Control of Pollution Act 1974. For air, we have Prevention and Control of Pollution Act 1981. Now, labor welfare, we have ESIC, Employee State Insurance Act 1948, ECA, Employees Compensation Act 1923. We have Maternity Benefit Act for Women 1961, Payment of Wages Act 1936, Minimum Wages Act 1948, and Child and Adolescent Labor Prohibition and Regulation Act 1986. And for the buildings, we have this National Building Code NBC 2016. So these are all the laws that is there in India. So now we are going to the next, that is United States of America, US. So their main health and safety law is the Occupational Safety and Health Act, that is also called as OSHA Act 1970. So they also have the supporting sector specific laws, and OSHA is their main health and safety law. So here US health and safety laws are also aligned with international standards and ILO guidance. So they also follows it. Now China, their main health and safety law is the Work Safety Law of the People's Republic of China 2002. China also follows the ILO conventions and international standards. Japan, their main health and safety law is the Industrial Safety and Health Act 1972. They have their industrial sector specific laws, and also Japan's health and safety laws are also aligned with the ILO conventions and international standards. They have a good standards practice in health and safety. Now Singapore, their main health and safety law is the Workplace Safety and Health Act WSH Act 2006. Singapore also, as we can see, they have the sector specific laws, and also they also follow ILO conventions and international best practices. Now UAE, there are a lot of Indians, a lot of Bangladesh people, a lot of Pakistan people, a lot of people are working in UAE. Not only the state countries, but from different corners, different like countries, people come here and work together from different countries. But most people, or the majority of people, are said are from the state countries, like I said before. So UAE has this main health and safety law, that is a federal law number 8, labor law 1980. So that sector specific law, you can see ministerial order number 32, UAE Fire and Life Safety Code of Practice 2018, Environment Protection and Development Law 1999, Construction Safety Regulations, then Oil and Gas Agency Regulations for ADNOC, and sector specific standards. So UAE health and safety laws are aligned with ILO conventions and international standards. So UAE also follows this. And if I am a person now working in UAE, it is my duty and responsibility that even though I was working in India for like around 8 years or 10 years, and now today I am working in UAE, I should be familiar with the country's law. I should have to know it. If a person who does murder in India, the law is different, and for a person who has committed a murder in UAE, both laws are different. If I say that for murder in my country only 7 years is a punishment, and in UAE I was not knowing that law, like how many years of punishment is there. So kindly please excuse, like kindly please uh, forgive or like such conditions, or give punishment me as per my country's regulations or law. Those are not acceptable things. Ignorance of law is not acceptable. So you should be familiar with the law and the main laws of the countries where you work within. So as we see, this is the main health and safety law of UAE. Saudi Arabia, their main health and safety law is the labor law of Saudi Arabia 2005. They also have their sector specific laws: occupational safety and health regulations 2014, civil defense law fire safety 1986, environmental law 2001, construction safety regulations, oil and gas safety regulations, Saudi Aramco standards. So Saudi health and safety laws are also aligned with ILO conventions and international standards. Qatar, their main health and safety law is labor law number 14 2004. As we can see, the sector specific laws: ministerial decision on OSH measures 2005, fire safety law civil defense 2014, environmental protection law 2002, construction safety regulations, oil and gas HSE regulations, Qatar energy standards. So here Qatar also follows the ILO conventions and international standards. South Africa, their main health and safety law is the OHSA 1993, Occupational Health and Safety. So they also have their sector specific laws. And here South Africa's law is also aligned with ILO conventions and international standards. Canada, here the main health and safety law is the Code Canadien du Travail. That is the Canada Labor Code Part 2, Occupational Health and Safety 1985. So here Canada, they also have their sector specific laws, and also they are also following the ILO conventions and international standards. Now Australia, their main health and safety law is the Work Health and Safety WHS Act 2005. They also have their sector specific laws, and the Australia also follows the ILO conventions and international standards. So now we have seen all the countries' main health and safety law. They are supporting sector specific laws. So this all got a good standard practice when the international framework from the ILO came. So in all the countries that was following the conventions and recommendations and guidance and everything, so what is the convention and the recommendation? So which convention and recommendation? So what is a convention? We can see over here. That is ILO Convention C155 of 1981, Occupational Safety and Health Convention. See, what happens is, now you have heard in the UK it is 1974. Okay, Health and Safety at Work Act 1974. See, what happens is, there will be countries that will have their health and safety law before even the conventions or recommendations came, even they could have it before. Okay, but as I said you, it is country specific, which means their country, it will have limitations, not international level of standards. So what happens is, when an international framework is created by ILO, they not only focuses on one or two countries, the whole countries, the problems that they face, how improvements can be made, all these things are noted, research being done, and finally they create these conventions and recommendations. So in safety, health and safety, C155 is the biggest convention for occupational safety and health that is been followed from that day till today. An international legal convention by the International Labour Organization. So this is an international convention. Do India follow it? Yes, we had seen India follow it. See today, as I said you, around 185 above countries are like there in ILO, and in that majority of the countries are following the conventions and recommendations or this international framework. And also they make understand like what are the duties of the governments, what are the duties of the employers, workers, and what all things need to be done, how and what health and safety practices is to be followed in the workplaces, machinery, substance, and work systems, how it can be improved. So in every countries, most of the all majority countries, health and safety foundation is this international framework. So this international framework focusingly every country's foundation of their national health and safety law was created. Now we have this ILO recommendation R164. As I said before only, there is this C155 convention. If the convention is saying to implement health and safety practice at the countries, R164 is a recommendation how you can do it practically. It is a complete explanation how you can proceed with that, how you can practically implement it. So it is like a supporting guidance for the convention of C155 and how you can apply the principles. So C155 is like a principle. It is like a set of principles being said, and R164 is like how you can implement it. R means recommendation, R164. C155 means convention 155. So this R164 actually gives practical measures for employees and workers. See, this both the thing C155 and R164. It is not something that it is like every country should have to or are legally binding, which means you should have to do it compulsorily or like such necessity. It's not like that. There are countries who are there in the ILO and to develop their national rules, laws, standards, practices, procedures in health and safety, they adapt, ratifies it, and they adapt it in their national laws. And once they adapt it, they should have to follow it. They should have to align with that and should have to follow it. So by doing so, what happens is there will be a good practice and it actually benefits that particular country and develop it. Now we see like what is the C155 in deep. Before that, I will show you how the C155 actually, how the structure actually looks like. So this is a C155 document. So in this, all these principles are said. So this is a document of C-155. C-155 Occupational Safety and Health Convention 1981, number 155. So now let's see one by one. See, it is completely like a principle in that scope, coverage, definition, and all these things are being written in that. But we are going to see the important things over here. Rest can be read. See, Article 1 is scope, like where all, in which all branches this thing applies, and coverage, that could be workers, workplaces, and all this definitions of like what is a workplace, what is worker, employer, health and safety. So this all basic things are there, and we can read. But the important thing is over here is like the Article 4, that is a national policy. What is said over here? Each country must have a national OSH policy, occupational safety and health policy. So we had seen in the past slides the countries that they were having a national health and safety policy or like their main health and safety law, OSH policy. So every country has it. So that is there in this Article 4. This principle is said in the Article 4. So Article 5, policy content. Policy must cover workplaces, machinery, substance, and work procedures. So this is very important thing. In the workplace, there are these machinery, substances, and we have our workplaces where we work. So in the policy, this all thing needs to be included. We know that there were laws for construction industry mainly. So that is a workplace. So you have like a specific like law for that or like guidelines, codes, and everything for that. The content is that particular content is also included in that. Then you have the Article 7, that is implementation. Governments must implement the policy through laws and system. So this policy, this law is to be made sure that it is implemented in the system and been followed. So Article 8 is enforcement. Laws must be enforced by inspection and penalties. Just think if a industry, if a company, if a sector is not following, so what happens to make sure it is to be followed? The enforcement agencies, the enforcement departments make sure it has been followed by inspecting that particular workplace, work sites, and if they don't follow, then providing them required like letters, notices, and everything. And if still not following, then giving like applying them penalties, like enforcing them. Then you have Article 9, that is the inspection system. So this is also important. Countries must have an effective labor inspection system. So by inspecting a particular workplace, we understand the condition of that, how it is going. Is it good? Is it like working smoothly, or is it going in a bad condition? By inspection, this has been understood. Then the main thing comes, that is the Article 13, that is worker rights. Now, worker rights, workers may remove themselves from serious danger without any punishment. Just think you people are a health and safety officer or a safety officer at Bhopal gas site in the Union Carbide. Just think, just go in the past, like you people are working over there as a safety person. It could be safety person, it could be a normal worker, it could be an operator, it could be from the management, like any such worker. Just think, you understand that this Union Carbide company in Bhopal, they are not following proper safety practices, and in by today also there could be any dangers that could happen, or in future also there are very risks. Even though this concern is been said to the senior management, they are not taking any action, and they are only focusing on production, decreasing the budget, and all these things, in which we have a potential threat or a serious danger that could affect our life. And in such a condition, what happens? We have a basic like right to live, right to life. It is not that wherever in whichever sector we have to work, we should have to lose our life. There is no such things, or we should have to make compromise with our health and safety concerns. Never. So in such a condition, just think if a company is saying that there should be like 30 days notice period or 45 days notice period or like any of the notice period, 60 days or whatever things it might be, and they're putting any conditions and all those things, you have the right to like leave that particular place. But remember, serious danger. In such conditions, you can leave that place. So that is your right. So if it is a worker, like if I am instructing, if I am an engineer, I am saying to the worker, you don't wear a safety belt. Just do it is only just 2 minutes work. Go in the building's outer section, stand in the edge, and do the work. So the workers can refuse. I cannot work in such condition, and he has a right not to work. And if still I am saying you should have to work here or like get lost from here, and if that worker understand that, just think if it was his first day in that particular company, was not understanding how health and safety practice is been followed, but now he got an idea that not only one staff but entire staff doesn't have any health and safety in their mindset, the practice is very poor, so there is no requirement, he immediately can like remove himself from that particular place, he can leave that site, and by followed by any matter legal thing comes to him, by saying these points, the serious potential dangerous threat to health and safety, the worker's right, he can remove from that particular place. Now, Article 15, that is the employer duties. We had seen before also, the employer should have to make sure that the workers and people, staff, everyone comes to work in his particular workplace. It could be his site, it could be his unit, it could be his factory, it could be his like area. So he should have to make sure that the working environment or the working workplace is safe. The system is safe over there, and the equipment, everything is like safe to work. Then Article 16, you have the workplace safety. Employers must control hazards at the workplace. Now, there are hazards that could turn or lead to risk, and hence by that all hazards needed or needs to be identified, and this employer should have to control that and make his workplace safe. Now, Article 19, that is workers' participation. Workers must be consulted and involved in occupational safety and health matters. That means in health and safety, there happens a lot of things: training, induction, toolbox talk, drills, practices, and all these things, programs, and all these things. So, there should be workers' participation. because all these said above things, as I said, you training, participation drills, and all these things, they should have the knowledge because they are the people who are like in the exposed to work and like have the highest potential to face accidents and all these things. So they should be educated. They should have been given the training, knowledge, and all these things. So workers' participation should be made sure that there is workers' participation. Then you have the Article 22 that is reporting. Employers must report accidents and dangerous occurrences. Wherever any accidents happens, in which we can understand that it's a complicated case and that needs to be reported to the authorities, to the concerned departments and agencies, then you should have to report that accidents and dangerous occurrences. In the case of Bhopal also, where the gas was leaking and all such things happened, it should be reported to the concerned agencies, concerned authorities, concerned institutions, and everywhere. Because while reporting, the actions that is to be taken will come, which means help will come on the way. So reporting must be done. So this is C155. So what I have done is the document, we have taken this in short. This is C155. This is how a C155 document is. Now we come to recommendation, ILO recommendation, or also called as the R164. Here you can see in the first scope and definition, paragraph 1, what it says is, see, now we had seen the C155, all the principles. R164 will say you in a practical guidance how you can implement it, like how you can practically do it. So paragraph 1 says applies to all industries and workers, self-employed should also be protected. Second, technical fields of action. Paragraph 3 says hazard should be eliminated at source across workplace, machinery, substances, welfare, PP, fire prevention, emergency, and health surveillance. Which means all hazard should be eliminated at places like the workplace, machinery, substances, welfare, and all these places. There should be no hazards. So PP is welfare, fire prevention, emergency, health and surveillance, all this needs to be focused. Action at the national level. Authorities should issue laws, review them, conduct research, give guidance, prevent disasters, and protect vulnerable groups, vulnerable workers. Which means the authorities, they should have to make the laws, and when there is a main health and safety law, supporting law, sector specific laws, what happens is when the time passes forward, there are a lot of like modernization, there are a lot of improvements that happens in there, in which there should be review, which means in the modern times, if you have a law that is very older, like very back of decades, then there will be lapse in that, or like it will be not be that much amount of beneficial, and hence there should be review, which means like it should be identified like what all changes are required in that, and by that amendment should come, which means that the main health and safety law will be like that only, but in that improvements will come, changes will come in that. So as time goes on forward, the changes also comes in that. So for that, yes, we need to conduct research and identify, understand. There should be like guidance being taken from different institutions, different sectors, and mostly we should have to prevent disasters being coming and protect the vulnerable workers. What is a vulnerable worker? That could be a senior citizen, like who is a aged person. That could be like a woman in maternal stage, like a pregnant women. They needed to be given special care and like conditions in the workplace. Also, there are various groups been identified as vulnerable workers. So all these people needed to be given care. Why? Just think, an emergency condition happens in a commercial place. It could be like a shopping mall. So there are a lot of too much amount of footfall over there, which means there are a lot of customers, clients, and everyone in that place. So when there happened a fire or like major fire, so all the people will run over in this condition. So the people who are good condition, in good health and everything, they will run. But the people who are vulnerable category, they have their conditions, like they have their limitations of health condition, and it will take a time for them to for the evacuation and everything. Like comparing to a healthy person, like running, and this vulnerable people, they have the limitations. So comparing to healthy person, this particular like comparing to normal person, this vulnerable people or vulnerable category people, they will face a lot of dangers or risk in this particular fire condition. As I said, you major fire or like emergency condition, they will face issues in that. And to these people, evacuation, rescue, and all these things need to be given on priority, and make sure, especially they we should have to give attention to that such cases. Now, action at the level of undertaking. So, employers must provide safe workplaces, training, supervision, PP, safe hours, and control fatigue. So, this employer should have to make sure. Now, paragraph 12, that is workers' safety representatives and committees must be supported and protected. So, there is a safety committee, from that workers are also there. So, it should be supported and protected. Then in the paragraph 16, workers must follow safety rules, use PP, and report hazards and accidents. We've seen before that employers must provide PPs, like safe workplace and all these things. So here see paragraph 16 is saying workers must follow safety rules, use PP, and report hazards and accidents. Just think, if a company is good in health and safety, like they provide all the required budget, all the required PPs and everything, and they do good health and safety practices, their documentation is good, and all health and safety record is good. So in a site, around 100 workers are there, in which one worker, he is not following the company has a policy in that site, follow compulsorily PPs and everything. But this person is not following a PP. he is like a regular or like a repeated safety violator, which means he has already got penalties and all this thing, but still not improved. And one day he had removed his helmet and a tool fall in his head, which he had got injured. Here, if he goes for compensation, so in such conditions, the company can reject it by saying that he is actually a repeated violator. Already, the company has instructed him to comply with the rules, to use PPs, but he has not done that. So here, the worker has also their responsibilities to be committed, in which there are basic things like follow safety rules, use the PPs, personal protective equipments, and report any hazards and accidents. This is a little important. Why? As I said you, the workers, they are like working. While working, there could be risk, so they can identify that. So there will be risk. So there will be hazards. There could an accident caused due to that working condition. So they should have to report it to the concerned authorities. Now, paragraph 17, that is, workers must not be punished for reporting safety concerns. See, in the Union Carbide also same condition happened when workers were reporting such conditions. They were punished, or like there were like threats or like warnings given to them. So that also is like one sort of punishment, like demotivating them. But a worker should have the freedom that if any of the safety concern is there, he can report it, and for that he should never be punished or never be targeted or no such things to be done against him. This is the beneficial for everyone, for him also, at the same time to the said person also, at the same time to the management, everyone. So that needed or needs to be taken into accountable. So this is the R164. Now this is how a R164 document looks like. You can look this. We had like made it little compressed and had taken the main points like made in short and understood. So again, we had taken all this main thing, what we had taken. So yes, ILO is a legal standard for occupational health and safety, C155, overall convention. So the main focus, see, of this is workers must ensure safe workplace equipment, substance, and system. That is said in Article 16. Risk controlled as far as reasonably practicable, which means however possible or to a good level of standard that we can do as far as reasonably practical, we should have to do that health and safety practice. Governments must create national OSH laws and inspection system. Article 479 says that. See, we had seen in the past slides only, but we had taken this all main things in this. Now, employer duties identify and control foreseeable risk is said in Article 16. Provide training, supervision, and PPs in Article 16 and 18. Prevent accidents and ill health in Article 16 we see this. These are the employer duties. I discussed this. So workers' duties and rights: follow safety rules and cooperate. In Article 19, use PPs and report hazards. In Article 19, right to leave serious danger without punishment. Article 13. So R164, it is a practical guidance to follow C155. The main focus is to eliminate hazards at source, safe design of workplace and machinery, control chemicals, fire, emergency, and fatigue, and all these things. Also, employers practice like training, supervision, safe hours of work, health surveillance, and OSH record, written OSH policy and monitoring, workers' participation, safety representative committee, worker protection for reporting safety issues for the workers, consultation on OSH matters. See, now this all things over here is like a practical how we can implement it is there. While you see over here C155, it is like the principles been said, what all things are to be followed. So this is a C155 and the R164. So we can understand this international legal framework is the main foundation of the national health and safety law or the main health and safety law of the majority of the countries and the main pillars or the main foundation of health and safety. Now we see the next thing, that is approved code of practice ACOP. Now understand one thing, workplace is such a condition where there is a lot of technicalities and industrial specific lot of things, some new modern things comes in that, which means a lot of technicalities are there in that, in which the law cannot completely identify each and everything. Now we had seen for construction, it had a construction specific law. So in that deep, each and every single points is not mentioned in that. The basic things are there in that. What all things goes in daily regular work, it is there. But when some new things come in that, new modern machines come, new modern like system come, all these things. For that, if there is not a proper law for that, and here technicalities are there a lot. So to understand the technicalities, how we should have to follow, which like what good practice we can do, we have this ACOP, that is a approved code of practice. Now what is an ACOP? Practical guidance approved by the regulator, explains how to comply with health and safety law, not law itself but has a special legal status. So here regulators, which means those are from the government institutions only. So they give this practical guidance how it is to be done. And there is a health and safety law, but when that industry does any technical works like that, so this ACOP like gives us the guidance that how you can like comply with that, how you can follow that with the same technicality, how you can do that. Okay, when a technicality or when a technical thing is like making you uh, like you understand that there is no particular law for that, or the law is not giving you specific thing how you should do it. There are this ACOP which will show you how you can do it properly. See, it is not a law, but still this particular thing has the legal status, special legal status. How these are accepted in the court, in the government institutions, and the industries also, these are accepted. Now, why ACOP are important? Following an approved code of practice usually means legal compliance. Even when a new technicality thing was came to you, you followed the approved code of practice while there was no law or any condition. The court will see that you have followed approved code of practices and that has a legal status, special legal status, and that also means you are following the compliance, a good practice. If not followed, duty holders must prove an equal or better standard. And if you're not following it, then that particular duty holder should have to make sure that what good or equally this or better standard practice what they have done, they should have to prove it. But ACOP is something that if you prove it, it is valid and it can be used as an evidence in the court. So some examples we can understand, that is safe use of machinery. We have some new machinery and the ACOP comes for safety, how it is to be followed, done. For work at height procedures, we have the approved code of practices. Like there should be proper staging, okay, and the quality of rigging, everything should be better. There should be some system to be followed, permits, administrative control, and the hierarchy of general hierarchy of control. All those things to be followed, and then we should have to do that work. So there are this approved code of practice that needs to be followed, and we need to do that work. So control of hazardous substances, how you should have to control such dangerous hazardous material substances. There is permit to work system in which ACOP is followed. To whom all is this approved code of practice being applicable? That is the employer, the managers, the safety officers. Yes, safety officers definitely require this. Just think, if there is a machinery, and that is very dangerous, very big machinery, and working with that is risky. So it will, that machinery, how to operate it. There will be the code of practices that will be there regarding that. How safely you can work with that particular thing. So that needs to be uh, looked in that, and you can follow that. Reference by inspectors during inspections. So this approved code of practice, what happens is, when institutions provide this approved code of practices, they will put in the external source, which means they will put in the website, they will put in the rules, codes, and all these things. So that is accessible to everyone. For one sector they have put, it can be used in all the sites, all the units, all the places, and everywhere. So it can be referred. It can be referred by the inspectors. It can be referred by the government staff. It can be referred by the safety officers. It can be referred by the managers. It can be referred by the CEO. Everyone. Then what will this do us? It will help goal setting. It will helps apply goal setting laws in practice. Which means, approved code of practice shows how to comply with the law, even though when there was no law. And if you ignore this law, it will make the legal defense difficulty for you. So for each and every work we do, there are a approved code of practices, and that approved code of practice is accepted. Now we are seeing a situation over here. In that we are seeing practical example. We will see a situation, that is workers doing work at height on a platform that could be a oil rig platform in the sea, in the offshore, as you can see in the picture. So here, what does the approved code of practice say? It says, the guidelines say, use guardrails. So you can see the guard rails are used that provide them a proper safe access over there. And when people are working, there should be proper supervision. Which means, just think, if a person is working alone in a risky area, and if anything happens, the in working at height, he falls in the sea. So help should be provided. And if there is no supervision over there, no person is over there, the things can become more complicated and dangerous. And hence, by there should be supervision on such work. anything happens, just think, if he doesn't fall in the sea or if he is like hanged in the safety belt, then he himself cannot raise up. There should be assistance, there should be supervisions, there should be help being provided to him. So it should be ensured that proper supervision is there. Then what employer did? So the employer should make sure that approved code of practice guidance is fully followed. They have installed the guardrails as you see, and also access ladders to be provided. So by doing this thing in the work and height, this basic thing, if you do it, what is the outcome or the result that happens? The outcome or the result will be, it will be a safe working place and there will be no accident that will occur. When you do such type of practice, the inspector understands, then the inspector is also satisfied because you follow the code of practice, and the employer is also considered legally compliant. Now here, even though following all this approved code of practices, and if any natural accident happens, any such failure happens, but still all the approved code of practice is followed in a good condition. Here, the employer is not liable because they have done their best, and everyone has done their best. But still, see what happens? Accident happens due to any of the reasons. Been uh, not any fault from the worker, not any fault from the like the employer. So in such conditions, what happens is both people are not liable and they are legally compliant. Now here we can understand that following approved code of practice is like, it is a strong proof of compliance with law, which means we have done the compliance properly. And this approved code of practice, like it turns the legal duty into practical action. And this is the approved code of practice. And for each and every work in health and safety in the workplaces, there will be the approved code of practices that we have, and that should be referred, and we can do a good health and safety practice at the site. So all the steps will be mentioned here. Only less steps I have mentioned, basic thing to understand, because health, work at height is everywhere. Most of the industries work at height has been performed. So in such a condition, this all things, basic procedures are there, basic approved code of practices need to be followed, and that makes legally compliant. That is a basic standard to be followed. So this is approved code of practice. So now where will we get such approved code of practice? So the competent, because the approved code of practice is something, there should be some standard and everything. So competent departments, institutions will have to give it. So in the UK, it has been provided or issued by the Health and Safety Executive, HSE. This department, who is the main department for health and safety in UK, this government department looks and issues the approved code of practice, and in that country, for ACOP it is called as approved codes of practices, ACOPs. So it is used by the employers, by the inspectors, and by the courts. They refer this. Now in India, this is issued by the government authorities from the central government and from the state government, and we call it as, or like it is found as, like rules, it will be codes, guidelines, and SOPs, standard operating procedures. We also find it in the OSH code 2020, occupational safety and health code. 2020. It has also been found in the Factories Act rules, sectoral rules, like each and every sector rules. The function, it is similar to approved code of practice, like practical compliance guidance, how to be done. So in the US, this approved code of practice is issued by the OSHA, OSHA, that is Occupational Safety and Health Administration. So this is their like country's department that looks after it, called as OSHA Standards and Compliance Directives. Okay, so here it is called like OSHA Standards and Compliance Directives, and OSHA's guidance is enforceable and used during inspections. So these countries, we can see they have their ACOPs been shown over here, and it has been followed like that. Now, what does enforcing health and safety laws involve? Which means we have seen there is a law for health and safety. Every country has their health and safety law, but having a health and safety law doesn't makes like you will have a good health and safety system. For that, you should have a good enforcement team, enforcement agency, enforcement departments, and this enforcement inspectors or like the labor inspector, and all these departments, when they implement it in the ground reality in the industries and everywhere, like this law, so at that time there happens a good health and safety being followed. So what does this enforcement involves? Ensuring compliance with statutory health and safety laws, preventing accidents and occupational disease, controlling high risk work activities, holding duty holders legally accountable. Purpose of enforcement is immediate control of serious risk, sustained compliance with health and safety laws, accountability through notice and prosecution. So there are some key enforcement principles have been said that we'll see in deep. So here what happens is this enforcement, like their main duty is to make sure the compliance is being followed of health and safety in various sectors, and they have a main intention that is to prevent accidents and occupational disease, and they mainly controls and focuses on the high risk activities or like work activities or sectors. And if any like company or industry is not following, and which is making like a major issue and all these things, so then that particular duty holder is made legally accountable, like prosecution and all these things, liable. So this is that particular like enforcement in health and safety. So we will see this key enforcement principles little deep. So these are people like who are the like safety inspectors. It will be like the labor inspector. There are various enforcement agencies and departments that work that we will see. So this is the basic like sort of require in the industry their sort of like work they do to control. Now we see key enforcement principles. First is proportionality, second targeting, third consistency, fourth transparency, fifth accountability. What is this? First, enforcement action matches the level of risk and harm. Minor safety lapse, improvement notice, serious risk, work stopped. Which means, just think an example, a construction industry is there, and there, like they have not followed. Just let's think if it of like of health and safety matter of health we will take, which means in the labor camp hygiene is not maintained properly, and hence by stagnant water is there, and leading to that dengue cases has arisen, dengue mosquitoes, and NS1 agent like dengue cases are rising over there. And nearby there is a government institutions and also jail is also there. So we know jail is a place where like people are also inside. So from this place, a lot of dengue cases, and this dengue mosquito is affecting this public area, this area. So here, this health inspectors, uh, this people should have to visit the place where this issue is causing, this construction industry, construction sector site, and they should have to, in the beginning, give them the required like improvement notice. Direct action is to be not taken. Give them improvement notice that due to this of your condition, it is affecting the public, and hence when a notice is given, so kindly this risk you should have to stop it, like make improvements in that and make sure it has been cleared. So this is regarding health matter. Now in safety, understand worker, there are 100 and 200 workers, but they have not given the PPs, which could have a serious risk if any of the incident or accident happens. So in the initial stage of the particular site will be given a improvement notice to do it. So this is proportionality. Like if it is a minor safety lapse, then improvement notice to be given. But if it is a serious risk, okay, just think they are doing a work in a particular unit in that place only, but their risk is high, and their accidents and like dangers will definitely happen. In such a work, such a condition, you should have to stop that work. So when you see like a minor safety lapse, then give them improvement notice. But when you see a like major safety lapse or like major serious risk, then you should have to stop that work. So this proportionality should have to be maintained. We as a health and safety practitioner, sometimes we could be working in a for a company, sometimes we could be working for a government institution, sometimes we can be a like government client, uh, in different types. Sometimes even we can be an health and safety inspector also. So this proportionality principle should be followed. Minor safety lapse, so such high action to be taken. If it is serious risk, then high action to be taken. Second, targeting. Enforcement focuses on activities with the highest risk, which means if an inspector is there and he is working in a place, so he should have to identify and target all the high risk like places, and the focus should be mainly on that. The focus should not go on like small industries, or like where the risks are less, or like any small construction places, or like that. You should have to focus mainly on the like where there are highest risk. Target should be there, and inspection should also be mainly carried on that places mostly. And now third, consistency. Similar breaches receive similar enforcement actions. Now that should be consistency. That means we are a safety inspector, and in a city there is one construction industry like A, there is other construction company named B. Now in both the places, what happened is PPs is not being issued by the company in both the places. So the action we should have to take as per proportionality, and same action is to be taken. Same condition, same action, which means same unsafe practice is been followed at two sides. So same legal notice to be followed, same action to be taken. It is not like that one action, a different action is taken here and a different action is being taken over there. No, practice, the unsafe practice is same. So the action taken should also be same. And next, transparency. Reasons for enforcement decisions are clearly explained. So when the inspector takes an action, if he gives a legal notice, then inspector documents, then the inspector should also make sure that the document should also make understand why that prohibition notice was issued. There should be transparency in that, which means the prohibition notice should have to make understand that the enforcement action was taken, that why it has been taken. There should be proper transparency in that. The document should have to reflect the condition. And now last, that is accountability. Duty holders and authorities are responsible for their actions. Here, if the required compliance, safety compliance is not followed, the construction company, safety PPs are not being provided. One, like improvement notice was given, again improvement notices were given, penalty was taken, still not improved. Then the inspectors have the accountability to take them to prosecution, prosecute them for not following safety or not following health and safety practice or not doing the compliance in safety. So prosecution, so employer can be prosecuted after repeated non-compliance. So what is prosecution? So now we see what is prosecution. Prosecution means legal action taken against the organization or the individual for serious health and safety failures. See, when for minor like a risk or minor harm, low harm, and all this been uh, happened in an like sector in industry, there the action takes is like the severity of the harm. Okay, for like minor things and everything, what happens is there is advice being given by the inspector, by the enforcement agencies. Warning letters are issued, notices are given. Then again, the compliance orders and all these things are being given in the initial stages for the minor risk and low harm. So this is the stages of prosecution, how it goes, and basis on the severity. But when the risk or the harm increases, in such conditions, there are improvement or prohibition notice, monetary fines are there, compensation is there. So you have the financial losses over here. And then for serious breaches, which means there is like very dangerous, danger practice and serious issues in health and safety practice. Major accidents and all these things have been followed. In such conditions, there will be criminal prosecution, heavy penalties, license cancellation, and even the plant will be also closed, plant closure. And imprisonment of responsible managers or directors in case of fatalities or major disasters. Just when there is a catastrophic or major disasters that happens and fatalities are happening over there or happened, in such condition, the managers or the directors are also responsible for imprisonment, which means jail and following legal conditions. We will see that in deep. We can see the examples of prosecution in the Bhopal gas leak in the Union Carbide. Thousands were killed and injured. Company had to pay penalty as 470 US million dollars. The punishment was also there, like around 5 to 6 members were to face imprisonment of 2 years. So, like that, in the deep water horizon, offshore explosion, oil spill happened, workers' death also happened. The penalty was like US $20 billion in fines, the cleanup in the sea, and the compensation. Here, the punishment was also like criminal charges against the company, senior level accountability. So, this is how the prosecution goes, which is punishment like imprisonment has also been faced. In the case of Chernobyl, what happened was the impact was when this explosion happened, the radiation was completely exposed throughout the across the whole country. It was like massive amount of radiation was going on. The complete country was like evacuating over there, that particular place completely. Not the country, the people in that particular place they were evacuating to different places. So this much amount of big impact that happened. And due to this, there was a very big economic losses. State bore enormous economic loss. Understand one thing, we know in the world there are a lot of nuclear projects that happen, power projects, weapons, and everything. This happens secretly also. When war happens, it is a very strategic thing to attack the enemy's nuclear bases. By doing so, it is a very big tactical move that later what happens with the enemies, they have to put a lot of fundings to clear the upcoming effects and to control the situation of the radiation and everything. That is like a very big financial impact causing condition. We know that such conditions has been seen in the war conditions. So in this case also, Chernobyl, the penalty was there. The punishment you can see over the plant director. See, the plant director, which means he is from the top management. The senior engineers were imprisoned up to 10 years. And later there happened a good global nuclear safety laws was strengthened. Now you can see in UK the Piper Alpha disaster cases also. Here the offshore platform explosion happened, many fatalities, death happened. High heavy civil penalties and compensation was to be faced. The company was held liable, legally accountable for safety failures. And then complete reform of UK offshore safety regulations was made. Good improvements been made. So here you can see what the punishment is there. The prosecution is different from all these different cases over here. But imprisonment, you can see the worst cases that happens. Now, to control all these things, there is this labor inspector, and they have been given their duties and rights, in which we can see there is the International Convention for Labor Inspection, 1947, that is the ILO convention, that is C081. We had seen C155, we had seen R164. So here we can see convention C081. So that gives labor inspector or legally empowered to, they can enter any workplace freely without intimating any prior notice. Just think, if I am a health and safety practitioner in a particular company, and there it could be like a pharmaceutical industry, it could be like any industry. While working, I had understood that the company is working in such a condition that will lead to a very big industrial disaster in the future. Even though I had instructed to them, the management is not taking any action, and all these things. Here, in such a condition, a health and safety practitioner can do the best is inform to that particular labor inspector. Things become confidential, and they will do an inspection. So, health and safety, the labor inspector is something like that. No invitations or no prior notice, nothing, and the industries cannot even stop them. Also, strictly, they have the rights as per law, as per the international law, as per the national law also, that they are to be permitted inside. They can check your documents, your safety related documents, the records and everything. Documentation they can completely, entirely check. They can do the investigations, interview with the employers, workers, ask them the conditions, ask them their issues and everything relating to their duties and the rights that has been given to them. And this inspector, they may also like issue written notices highlighting non-compliances. If something properly is not followed, they can give it in a written notice. And if there is an unsafe condition, they can give you like orders to follow it. And if they find any like dangerous working conditions, they can prohibit that work on the spot immediately. Like stop the work, stop memo. If they feel anything, something is dangerous, any material, they can remove the samples, equipment, or material for testing and analysis. So they have the rights for that. Seek expert or third party opinion when required. This all thing they can do. So now here the labor inspector, see, labors are there in every sector. It could be pharmaceutical sector, shipyard, dockyard, port, aviation sector, everywhere. Like see, different sectors are there, and labors work over there. So these people have the right to enter the places. So for that, this international convention is giving the power, and like all these rights and powers are there, and the same thing is applied in the and adapted in the national laws of every countries that has been followed. And that we can see over here, like the health and safety enforcement authorities in India, we can see that is Ministry of Labor and Employment. That is they make the complete overall policy, safety policy, labor law, occupational safety health code enforcement. Then we have these are all the enforcement agencies, enforcement authorities, enforcement government institutions that we have. Then we have the Directorate General of Factory Advice Service and Labor Institutes, DGFASLI. So they mainly focuses on the factories, dock, industrial safety guidance and inspections. They do mainly focusing to the factories and everything. Then you have the state labor departments and inspectorates. So as per every states, they have their labor departments and inspectors, which mainly focus on the factories, construction, and labor safety laws at state level. Every state also have their different labor safety laws as per the conditions that they face. Then you have the Directorate General of Mine Safety, DGMS, for the mines health and safety practice. Then for the petroleum and explosive, we have the Petroleum and Explosive Safety Organizations, PESO. Then for the nuclear and radiation safety regulation, we have the AERB, that is Atomic Energy Regulatory Board, and this is applicable in all the places. Atomic energy. See, one basic example I will say to you over here. In the hospitals also, there are the X-ray machines and machines and all these things, X-ray machines and everything. In that also, and there are like machines, medical machines, which has this type of radiation thing, and due to that, those machines are also being like regulated by the law of AERB, that is the Atomic Energy Regulatory Board in India. These hospitals, and the AERB has their law, and if this is been not followed by this hospital, then the legal action, the enforcement authorities from the AERB will be taking the action for them, for that particular hospitals and all. So in the hospitals, the machines are there relating to radiation and everything. Then the nuclear power plants, then the weapons and everything. This has been regulated by the AERB. So they are also the enforcement agencies. There are people who does the enforcement in that. Enforcement, which means like enforcing the act, and if not done, then following the legal required penalties and all the state like prosecution and everything. They move it. Then you have the Directorate General of Shipping, DGS, Maritime Safety. So it is for the ship and the law relating to them. Just think your ship is there that is carrying a large amount of crude oil, and the ship has a leak and it is polluting the sea water in the Indian Ocean. Just think an example in the Indian Ocean, not in the international water, but in the Indian coastline. So this agencies can take action on them as per the law. So we have the Director General of Shipping, DGS. Then we have the Central Pollution Control Board, CPCB, that looks into industrial pollution control and hazardous waste regulation. Here again, just think if it is a hospital, let's understand. In hospitals, what happen is they have the biological medical waste, which means after the surgeries and all these things, there are like a lot of biomedical waste. And as per the CPCB law, the hospitals are to be like collect all this waste, separate, do proper separations and everything, segregation like separate and everything, and this should be disposed from a proper channel. That should be the proper vendors that is registered, and it should be gone to them for proper disposal and everything. That method should be followed, and if that is not been followed, the CPCB will be taking action of that, which shall include the penalty, legal fines, and that is very high. So then we have the State Pollution Control Board, SPCBs, that looks into environmental health and industrial emission enforcement. So CPCB, SPCB relating to the Pollution Control Board. Then we have the local authorities, municipal corporations for public safety, building safety, fire safety enforcement, and all these things. An example is like this. Just think there is a new commercial building that is coming in which there are a lot of people going to work. So the person should have to send the documents to the local authorities or the municipal corporations. They uh, like verify it, they checks the design and everything, and they implement like all the public safety required things in that relating to fire NOCs and all those things. So this is a department that is to be coordinated. And just think if it could be a shopping mall, and they had said fire safety, like fire lines and all these things to be implemented, and they had done that. But later, when it came to operational, to cut the cost of the electricity for the fire lines and all these things, which means the safety like appliances, they had done See, the fire lines, they are actually 24 into 7 hours. It is like standby, it is continuously operating. 24 hours it is operating. So to cut the cost, it is been off and been planned to operate while there is any emergency. So that is actually risky. These appliances are made to automatically operate. In such a condition, this particular corporations, when they understand, they can take action on this. Or these devices are not maintained properly, it is not working condition, so they can take the actions. So not only this, but also the public safety, public health, all these concerns, the corporations can look after that. Then we have the National Disaster Management Authority, NDMA, which mainly looks into major accident prevention and disaster response coordination. So this is the health and safety enforcement authorities in India. Then you have the health and safety enforcement authorities in the UK. We can see there is HSE, as we discussed before. They have the local authorities. For nuclear, they have their office for nuclear regulations. For maritime, they have Maritime and Coast Guard Agency. For aviation, they have Civil Aviation Authority. For environmental protection, they have the Environment Agency. They have also the Scottish Environment Protection Agency, SEPA, and also NRW, that is a natural resource of Wales. So this is UK's health and safety enforcement authorities. Here main is HSC, that is our main for like health and safety at workplace. Then we can see of US health and safety enforcement authorities, that is OSHA. It is their main authority for workplace health and safety enforcement. Then state OSHA agencies, state plans. Then they have the Mine Safety and Health Administration, MSHA, for mine activities, mine safety. Environmental Protection Agency, EPA, for the environment protection. Then US Chemical Safety and Hazard Investigation Board, CSB. And then the Federal Aviation Administration, FAA, for aviation safety. And then last, that is a US Coast Guard, USCG, for maritime safety, offshore facilities and ports, and the safety at the offshore. So these are all the enforcement agencies in these different countries. So we understand that the international law, the international framework from the ILO, that is being adapted by the national or the countries, and the countries have this law, and from that law, such enforcement agencies implement and make it into action. And if not properly done, then the required like compliances and required actions like prosecution, everything been followed. By doing so, this is how this is the foundation of how a health and safety is been properly followed in each and every country, and how it goes on. So this is the legal reason to manage health and safety. We had seen moral reason, financial reason, and now the legal reason. The legal reason is the strongest point and the valid thing. Due to the strength of that, all the other three things, all the other two things like moral and financial becomes more possible to operate, coordinate, and work in good manner. So we understand this thing. Now we take a small break.